Welcome back to another episode of Reddit Titan. In today's episode, the user asked the question, lawyers of Reddit, what's your best most badass I rest my case moment? Here are all the crazy answers, and don't forget to subscribe for a new video every day. As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial date be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92, and the case has already gone on for 5 years, the judge was visibly shocked, and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt runoff issues. Mr. Smith, WOULD, you agree that the book I holding is highly respected in your field and considered to be the gold standard on the subject? Witness, I am aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraph 6-10 on page 121 is describing? Witness reads the passage word for word. Yes, I can read, but could you put this passage in your own words for the court? Witness, these are my own words. I wrote it. We were the defendants. We were being sued by an HOA over silt in a lake. We were able to prove that we were irresponsible and prevailed. It actually originated from another site and entered the lake. Elsewhere, however, that site was owned by a very large corporation, and I don't think the HOA wanted to fight with an entity that could fight forever. So I call up my client's disgruntled former employee about a contract dispute that he started, and that got my client into litigation. After 2 questions, it was obvious he was a lying son of a bitch. I didn't want to call him as a witness. He was prone to act unpredictably. I took down his story as we talked, which was easily proven false by documents and which cast my client in a false and bad light. I did not tell him how I'd caught him in lies. Fast forward one day, I submit a list of known witnesses to opposing counsel, as required by the rules. Witness number 1 was the lying sack of shit. Fast forward to trial, my opposing counsel calls the lying sack of shit as his first witness, and the lying sack of shit acts like a lying sack of shit. He tells the same story on the witness stand that he told me on the phone. I took emails that he wrote and entered them into evidence and proved him a clear liar. My client didn't breach the contract, the party suing did. After the lying sack of shit left the witness stand, I asked the court for a brief recess. Granted. I approached opposing counsel. My client was still willing to sign on to the walkaway settlement where no money changes hands and no fault was admitted. We offered the deal 2 months before and it was angrily rejected. Now, suddenly, it was accepted. Score. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with the judge, who asked the driver if he had ever sped before. No, Your Honor, I never speed, was his reply. The judge asked him a couple more times if he was sure, if he never sped ever. The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it, and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Speeding. The driver had to pay medical bills for my sister. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client was and paying him correctly in accordance with the contract. During his deposition, Dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his dep, so I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what." He said the lawyer is never the one who goes to jail, that he is and going to jail for me, and if I lie, I on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I done with this guy." Not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that rule meant they could do X. I tried, multiple times, to point out rule literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where rule says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. I do mostly solicitor work, so if I'm doing my job right I don't get a whole lot of these type of moments. That being said, I had a long-time client who was being sued and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description and the non-compete confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out or he can find himself another job. He takes the latter option, but he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation and the only way he could get any of it would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Me: did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator: sir, answer the question. Silence. Mediator: well, let me ask it, did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator: I'll take that as a no. I was on the losing end. Represented a guy who had bought a company and the company failed spectacularly within months due to a number of reasons I could attribute to the seller, and they had clearly lied about the company finances to induce him to buy. I was suing to rescind the deal, have your shitty company back and give my guy his money back. I laid out my huge case and thought I had it in the bag, and then opposing counsel asked my guy, "Isn't it true that you listed this business for sale a month ago?" "Yes." "And you did sell it, correct? You signed the purchase and sale?" "Yes, but he never finished paying me. He has more payments to make. I'll just give his money back when you guys give me my money back. My idiot client had me suing over a company that he had legally sold. F***er never told me. Game over on the spot. This one was so solid, it never even got to become a case. I once had a client who was an office assistant. The doctor she worked for trapped her in the copy room, grabbed her breast, and kissed her while she fought him off. 2 nurses witnessed it as they came around the corner. She didn't return to work, and then called me for the sexual harassment claim. Investigation showed that the doc had done this 3 times before and was on his 3rd wife because of this behavior. I wrote a letter laying out the claim and asking for 2 years salary plus $20K as a demand, $85K all in. I gave the doc 3 days to respond. On day 3 I got a call from the doc telling me to go f*** myself. I ended the call by saying, I know you've done this before, and I wouldn't want to be you when your wife finds out about this lawsuit. You're bringing this on yourself. A half hour later, literally as I was drafting the complaint to initiate the lawsuit, I get a return call from Doc saying come get your money. It was beautiful. Hope you guys enjoyed that episode. If you did, please like the video and subscribe for future videos coming out daily. I'll see you guys in the next one.